Hello everybody and welcome to Keble College, Oxford. We're here today for the launch of the Routledge Handbook of Election Law that's just coming out today, and we've got a discussion planned for the next 45 minutes. One handbook overall and some of the topical issues that are talked about in the handbook and that there are in the world of elections. There's three of us here today for this discussion. So to my left, we have Jurij Toplak, who's one of the two co-editors of the handbook, so has put in a huge amount of work to make this come together. And he's a professor of law at the Alma Mater Europaea University. He's also a visiting professor of law at the Fordham University in New York. He's taken a number of legal cases related to elections in his home country in Slovenia, to do with disability issues, also to do with annulment of a referendum and the reinstatement of candidates. And as I said, he's been a co-editor, or he is a co-editor of this handbook. To my right, we have Ugochukwu Ezeh, who's a candidate doctoral student here at the Faculty of Law in Oxford. He's also been been on a scholarship for an MPhil in law, which he got with distinction. And following that, he was then at the Oxford Human Rights Hub as a research fellow in the Rhodes University in South Africa. And I'm Hannah Roberts. I've been working as an election practitioner for some 20-odd years now, mostly doing election observation. This has included being the Deputy Chief Observer on 5 EU election observation missions in Africa and Asia, and also doing a range of positions on OSCE, ODIHR, election observation and assessment missions, including as head of mission. I've been involved in running out-of-country voting and also working with election administrations. As I said, we'll be here today for about 45 minutes to an hour. If anybody watching has any questions, feel free to email them in to us, and the address is conference@almamater.si. So that's conference@almamater.si. So send any questions in quickly so that we have time to answer them. But first of all, we wanted to start with Jurij, just to get a sense of why you did this book. It's obviously been a lot of work to pull together chapters from, I think it's 27 different authors, covering a whole range of topics related to election law and the role of courts in elections, and also covering many different parts of the world and different issues that arise at different stages of elections and different geographical and jurisdictional terrain. So why did you go about this? What's it all been about for you, Jurij?
Thank you, Hannah. There were books on election law covering a single country, a vast majority of them on US election law. There were comparative books covering a narrow topic within election law, such as redistricting, electoral management bodies, or campaign finance. But we decided to do a book that would try to, as much as possible, completely cover election law from a global perspective. So we put special effort into getting best contributors from all continents, from all different areas of election law, and we ended up with a book that contains 27 chapters written by 27 contributors, and we believe it's the most thorough book on election law in the world today. I would stress that electoral disputes have been or violations in elections have been seen as a political issue until recently in most of the world. Now they're seen as legal issues. So violations in elections, that's how we see it now. They should not be solved by political means, by protests, by political debate only, but because they're legal questions, legal issues, they should be also solved by legal means in courts. And this is the core issue in the book. But the book covers all like 20 plus aspects of 20 plus areas within the election law.
So by having the book, hopefully there can be more understanding of the way that issues are being legally addressed in different jurisdictions, and so hopefully practitioners and others can learn more about the challenges faced and the solutions found in different parts of the world.
Yeah, we believe that it is a great resource book for anybody who wants to learn about election law in other countries. It can help legislators, practitioners, scholars who would like to learn about practices and rules in other countries and solutions the other parts of the world use. But here I would point out the chapter written by Ugo. It is very timely because as we speak there is an electoral dispute in Kenya, and Ugo's chapter provides a fantastic overview of electoral disputes and courts rulings in Africa. And I would ask you, Ugo, now, what are the main topics African courts deal with in elections? What are the main issues and trends in election law in Africa?
Thank you, Jurij, and thank you, Anna, as well. I'll start by expressing how pleased I am to be taking part in this conversation. And yes, election law, like you said, Jurij, is very topical. In the chapter that I contributed to the book, I look at some topical themes in the comparative African electoral jurisprudence. So I examine judicial determination of presidential election petitions in a number of African jurisdictions. I look at the ways in which courts are conceptualizing their roles in terms of providing practical legal remedies for violations of electoral laws, for infringements of rights. We're looking at legal remedies for cases of electoral malpractice or other forms of irregularities. But beyond that, the chapter also explores the relationship between courts and core democratic institutions like electoral management bodies, again, in a number of jurisdictions as well. And finally, I also explore the ways in which courts are disseminating constitutional norms and democratic values in the fledgling democracies and transitional societies on the continent of Africa. Yeah.
In your chapter, you mentioned or analyzed the Kenyan judgment of 2017
yes.
in quite a detail. And Hannah, you were the deputy head of mission for the EU observers in Kenya in 2017 when the Supreme Court invalidated the presidential election and the presidential elections were repeated. Let me just explain to those who do not know what election observation mission is, because I see it as a really fascinating situation when like 200-300 people come from 20 different countries, cultural backgrounds. They fly in the country in one day, and the next day they start working. Each of them has their own job. They don't know each other from before. They start working like I see it as an anthill. And you are in charge of the
ants.
of the whole anthill. And you did that in Kenya in 2017. Ugo and Hannah, both of you, how do you see the judgment? Because it was really a landmark judgment. It was one of the first judgments globally that asked the elections to be repeated, and it was the first one in Africa. How do you see that? There's, on one side, there's a risk that this would trigger violence, and on the other hand, there's benefits. How did you see the Kenya judgment in 2017?
Do you want to go first, Anna?
So perhaps from a lived experience, it was very testing for us, as it was for the whole country and everybody involved in that election. The court was under a lot of pressure because of the political tensions that there were between the two sides. And also they had a huge amount of evidence that they had to wade through. And if I remember right, there's a time limit of 2 weeks that they had. So they had an enormous political and practical load on their shoulders. As the days were progressing, we could see more of the rationale that they were following, and could start to see that possibly they were going to annul this election. And for us, that was a very key thing, that any decision by a court should be very predictable, so that it's not just based on one person's views on something, but it's something that is a logical consequence of the legal framework in a country and the evidence of what's actually happened. But still, when the decision came, it was a huge shock for us, because it had never happened before. And it was also had huge practical implications. So the election administration, the IEBC, had only a short time to make a lot of corrective actions. And there were a lot of improvements that were made. So we saw it as part of an evolution of raising standards that was very needed, particularly in regards to transparency, so that in the future people could have more confidence in election, and hopefully that also reduced the risk of dispute. But it's a tall order, it's a tough thing to do. And politically it was extremely problematic during that time. So it didn't, well, I think there's a long-term benefit, and also in the court being able to demonstrate its ability to operate independently by making a decision against the ruling party. It was very difficult on a practical level, but of course much better than going to the streets and there being violence on the streets. The other aspect that was very apparent to us was the amount of pressure that was being put on the judiciary throughout the election process in 2017, so before, during and after the election, when they were subject to extremely harsh criticism, extensive complaints and intimidation. This culminated with 2 days before the fresh election that was held, an attack on the driver of the Deputy Chief Justice, which appeared to have a very intimidating effect, to the extent that the day before the fresh election, the court couldn't get a quorum and therefore couldn't make a ruling that was needed. So I think one of the things that we would always be concerned about is the ability of the judiciary to be able to operate without intimidation, and to be able to make choices that are based on the law and the evidence, and therefore for there to be a predictability in the process.
Absolutely. It certainly was a radical intervention. It was one of the rare occasions in which a judicial institution is nullifying an electoral contest. But my view is it was also justifiable based on a plausible reading of the applicable constitutional and statutory frameworks in Kenya. And I do think that the decision did reverberate beyond Kenya's borders as well. One of the things I most admired about the decision was the court's emphasis on the need to conceptualize elections as a process, not just as a one-day event. So we look at to determine or to assess, evaluate the quality of an electoral contest, we need to look at the process leading up to voting day. And the court was very, or the majority court, I should say, was very concerned about the need to ensure compliance, meaningful compliance with legal principles, legal standards, constitutional values that have been enshrined in the Kenyan constitutional framework, as it were. You're absolutely right, Anna. It was quite a very testing period for the judiciary. election petitions are very significant, as we would imagine, very consequential events. The eyes of the world and the nation are trained on the judges, as it were, and that's quite a lot of pressure. And I also agree with Jurij as well. These kinds of decisions ultimately emphasize the importance of peaceful resolution of electoral conflicts. We want to channel many of these disputes into the judicial process so that the courts can pronounce on questions of rights and obligations and liability, and hopefully resolve the issues quite peacefully, especially for a nascent democracy, for a transitional society. That's key, I believe.
Perhaps to add to that, to say, because of the pressures the judiciary can be under in different countries, and because of the enormous burden there can be on them, it's critical that they are also subject to scrutiny through observers and through other stakeholders in the process, and that their actions are clearly communicated so that people can understand the work they have to do, the task they have, the way they're going to do it, the logic for their decision, the rationale, and can relate and have confidence in the conclusions that they make. And without confidence in those conclusions, there is, again, a risk that people will turn to the streets, perhaps with increased agitation if they no longer have confidence in the election administration or the courts. So there's a huge responsibility that goes with that, with the role that the courts seem to be increasingly being expected to play in regard to elections.
Yeah, I would say that courts' involvement hugely benefits the democracy. It's if the election was flawed, it invalidates election. But if the election was not flawed, it reaffirms the mandate of those elected. It helps voters clear their doubts, and it brings more trust and more transparency into the system. But in a situation where Kenya is now, today, waiting for the court to rule, or for the candidates to appeal and for the court to rule, I think it is essential that politicians and those and voters stay calm, do not encourage non-legal means of expressing their disagreement, and they respect the rule of law, and wait for the judgment, and accept the judgment, and that all of them commit to a peaceful transfer of power. And Kenya was one of the first, but in the last few years, several countries repeated elections. This is globally speaking. This is a new trend in the last few years. I think there's never been so many annulled and repeated elections as there have been in the last 10 years. It started with the Bush versus Gore in the United States, where the world saw that electoral disputes can go to court, and that there's a chance that the court would, ultimately decide who's the winner. Most of observers worldwide were criticizing that, but now this is what we commonly accept as the right thing to do when there's a disagreement about elections. And now elections have been annulled and repeated in Austria, Slovenia referendum in Switzerland, Kenya, Malawi, Iceland. So this is the trend. But Ugo, I would ask you about Africa, and how do you see trends in election law in Africa and in dealing with electoral violations? How do you see the trend in maybe 5-10 years from now?
Yeah, you're absolutely right. The trend is really one of judicialization of electoral conflicts. we have seen an increasing resort to judicial institutions to step in, as it were, and intervene to reverse some of these forms of democratic decline, really, electoral malpractice. We have several historical examples. The famous Nigerian case of 1979, where essentially the Supreme Court had to resolve a very contentious legal issue arising from the presidential elections in '79. We've seen the trend repeated again in 2017 with Kenya. We saw shortly thereafter the judicial decisions in Malawi, which interestingly led to the historic victory of an opposition candidate after the court's decision. I do think that the trend is likely to persist, to continue into the future. But ultimately, we should also be cautious about not overestimating or about overestimating the role of courts within these electoral processes. So I like to think of the problem in terms of the different roles that stakeholders, democratic stakeholders can play in terms of building democracy, democratic consolidation, as it were. So it maps onto the issue you were talking about earlier about disseminating judgments from courts, right? When courts hand down these lofty technical decisions, are they really intelligible and accessible to members of the public? Not necessarily. So there is, we as scholars, for instance, we do have our work cut out for us. Journalists have to intervene, they have to report the cases accurately and eschew sensationalism and misinformation. Disinformation is a huge problem. We need to see principled analysis of the work of judicial institutions and electoral management bodies. We need the electoral management bodies to sit up as well and win back the trust of the populace. We need to see election observers doing their bit, international pro-democracy partners. So it's a very multi-pronged problem, and there are specific roles for different actors in terms of building up credible electoral systems that deliver true democracy to the people.
When you analyze judicial decisions in Africa, do the courts rely mostly on domestic law, or do they rely on comparative experience, foreign law, British or some other law, or do they rely also on electoral observation, international organizations' findings? Have you noticed any of these being as a basis for the
decisions?
Yeah,
the trends in the cases, they're mostly relying on their national laws, their municipal laws. So the applicable constitutional framework, the applicable electoral legal framework, for instance. Courts are also drawing on judicial precedents from their own countries. But what I found interesting was the comparative judicial dialogue going on, especially on the African continent. So African courts citing each other, the Malawian courts citing the Kenyan courts, the Ghanaian courts citing the Nigerian courts, and vice versa. So we're seeing very interesting judicial dialogues going on. And it does essentially make for a rich electoral jurisprudence going forward. Yeah.
I guess it raises questions of also how courts are prepared for this responsibility that they're increasingly carrying when there is more jurisprudence within a region and beyond.
Absolutely.
But also the extent that they understand the legal precedents within their own country.
Absolutely.
The way that lawyers are prepared to argue their cases. I think there's a lot more focus that can happen on how the judiciary are equipped to do this and the role that supporting stakeholders play in supporting decision making.
The electoral observation findings can be a really valuable evidence for the court. And this is the chapter that you contributed to the book, the chapter on electoral observation. And the sentence that I marked in your chapter is, you say, a cornerstone of any credible methodology is clarity on the framework and standards that are being used for assessment in the electoral observation. Do we have clear standards? What are these standards? Where are they written? Where are the global standards on elections written?
So as observers looking at elections, obviously you can look at any election in many different ways, and we all know that people can have their own particular interests, particularly if it's elections in their home countries, and can see things in a certain way or interpret things in a certain way. So to get away from that risk of a biased analysis, it's really important that any credible observer group, be they observing in their home country or in another country, that they have a really clear framework for how they're going to go about assessing any election, so that it doesn't become subjective, but is an objective exercise. So for that, as election observation has evolved over the last 30 years or so, it's become more and more rooted, credible observation, in two things. Obviously the national legislation, so the laws of that country, but secondly, in the international commitments that a country has made in regard to elections. So essentially, as international observers, we only go when we're invited. And when we're invited, we're essentially looking at if the election process matches up to the way the country has said it wants to run its own elections. So we're not going in saying how we think the election should be according to our standards. It's according to the commitments that country has made. And those commitments are primarily contained within international treaties, international conventions that a country has signed up to and ratified, and also political agreements that it's made. And these are very strong instruments, because particularly the treaties are something, the UN treaties, that have a really near universal recognition, because so many countries have signed up to them. So it's something that's really like a global norm. So it's a very easy framework for us to refer to, because it's something that is so established. So the main instrument that we talk about, or that we use, is something called the ICCPR, the International Covenant on Civil and Political Rights. And this has been signed up to by, I think it's 173 countries. So you can see it's not about having our own personal opinion on an election. It's really about the commitments, the principles that are in these different instruments. And that's what we refer to. How a country matches up to those principles is quite difficult in practice to assess, because sometimes it can be very strong in one area and not in another, but maybe one area matters more than another. But it's our job to sort of untangle that and see what the most important elements are of where those principles are being met, but also where there are shortcomings. And to do that, we have to look not just at what's written in the law, but what happens in practice. So we need to see the ground reality. That's what our job is. So for that, we have to have these ants, as you referred to them earlier, Jurij, these observers that come, in the case of international observers, that come from other countries. And they work in teams of 2 around the country. They'll be in place for some 2 months, 6 weeks before an election, and some weeks afterwards. So they're really seeing what the truth is, what the sort of ground reality is of an election. And those are the criteria we use to assess an election. So I would say those commitments that a country make are not only really useful for us as observers, but more importantly, they're for the people of a country to know what to expect from an election, because their state has committed to these principles. So they're a great reference framework for looking, for example, at how to improve an election, how to make it better, when different parties may have different views and they're pulling and tugging against each other, to refer back to international law, international political agreements, instruments, and provides a natural framework for this is what's recognized as good practice.
I found it interesting when you mentioned this personal biases or personal incentives, different observers. So it's really valuable that there's a big group of observers coming from very different backgrounds, because I think we all have met observers who saw some practice and they said, "Oh, this is acceptable. We do it in our country too." Mm-hmm. And when the group is really diverse, then they can do a much better job over weeks or months of the mission. But my question for you would be, the standards that missions use, do they change? Is the level of acceptable electoral practices, is it raising or is it getting lower? Are you getting stricter against certain practices or elections in general because you've been doing this for 20 years. So are missions becoming stricter or more tolerant over these years?
So in terms of strictness, just to say we offer our assessment, we offer recommendations for improvement, and any observation mission is as much about future elections and how to make improvements for future elections as it is about the current election. But we have no mandate to enforce anything. We're offering our opinion. So in terms of our strictness, it has limited reach, let's say. But in terms of looking at compliance, at meeting these standards contained in international instruments, there's often grey area. In every election, there's some imperfection, there's something that's not perfect. And elections involve a balance of rights in many ways. There's trying to have maximum enfranchisement, but you also need integrity and safeguards in the system, and how do you get a balance between these two? So there's always things that can be improved, which is why any credible assessment needs to be very specific to that election, that particular context, to look at what the most important improvements are going forward. So when we look at how much a country is able to meet the commitments it's made, we of course need to consider the factors on the ground that may make it harder or easier to meet those standards. So if a country is doing an election for a first time, if there's an extremely difficult infrastructure or physical terrain, if there's a context of insecurity, it's going to be harder to meet those standards. What makes any election process better, even if there are shortcomings, is if there's a lot of openness in the process, so people are very upfront about problems and shortcomings. If they include stakeholders, so people can become part of the solutions or trying to work through a difficult situation. So all those sorts of things make us understand what the problems are a bit and sort of refer to the problems more with a view to improvement. Whereas if it's a repeated problem that's being hidden, not being dealt with up front, of course we're going to speak more negatively about that because it's it's a situation that would likely entrench further and therefore also be more damaging to future elections.
And you still allow, I mean, you as observers, you still allow countries to be unique in how they run elections. I would invite here readers of the book to read a chapter by Graham Orr, one of the leading Australian election law scholars. He wrote a chapter called Election Rituals, and he collected practices that are often unique to individual countries, and they make elections really interesting for to observe, to study, or to experience as a voter. I would also mention a few other chapters. In the book we have there's 2 chapters on money and elections, and very important. Then the chapter on by the co-editor David Schulz, who's actually the main editor. It was his idea. He is the father of the project. And Mark Rush, professor at the Washington and Lee University, United States, and of course the research done by Pippa Norris of Harvard University. She, together with Toby James and Holly Garnett, they rank countries according to the to electoral integrity, how experts see the integrity of elections in individual countries. And this is the ranking that made many upset, because some countries were, some old democracies, developed democracies, were ranked really low, such as UK and US. I would say I see it as I think that most of those who are shocked by the low ranking of US and UK are they don't take into the consideration enough that this is a perception index. So this is how experts see elections in these countries, and many of these experts who evaluated the countries, they're evaluating elections in their own countries. And British and American scholars, they're very critical of their countries, their laws, their solutions. On the other hand, there's many countries where experts are very defensive. They would not criticize their own country or their laws, and as a consequence, these countries are seen as the ones with the best laws and solutions and the elections. Probably they also are really good, or maybe the best, but I would say that this difference in how American or British experts see their own country compared to the Scandinavian experts see or talk about their own countries, this really affects the ranking. But the ranking is really interesting. The countries in the top are Norway, Sweden, Finland, Germany, and the Netherlands. And everybody else should look in the book to see where their country is. Before we finish, I would ask you, how do you see the electoral observation in the future? Where do you see it 5, 10, 20 years from now? Do you think it will continue taking place with about the same methodology as it does now? Or do you think that there will be or should be some major change in the process?
So I think election issues are always changing, and there's a sort of evolution of election challenges, most notably recently with the rise of social media, of course, and the use of the internet, which makes things like campaign finance issues, brings new complications for us. So I think as elections evolve, election observation needs to evolve. And in addition to election observation, of course, there are others who also play a critical scrutiny role. We as international observers come in with a very specific remit, but there are others, citizen groups, civil society groups, academia, who can also scrutinize, sometimes in a much more comprehensive, long-term sort of way over years. So I think it's really important that all the players are still doing their work. In terms of us as observers, as I say, we need to move with the changing challenges, but one hopes that there would be more and more focus on the contribution that citizen observers make. So citizen observers are observing in their own country, which can bring its own challenges, because obviously it can be more subject to pressure and intimidation and vested interests, but also have the advantage of often having more people being there on the ground for longer, and of course being part of the ecosystem of the election. So I think the more that they are strengthened in their role, given support to deliver a very challenging operation where there are many, many more ants involved, and the more that their voice can be heard as part of a process, the better. So I hope that as the years go on, as I say, they are able to play a bigger role and still be supplemented and complemented by international observation, but it move more towards that recognition of the role that citizens play in their own elections.
Ugo, how would you like to continue your research, where would you want to take it next?
So with the comparative African electoral jurisprudence, well, I would like to see more positive developments. I would like to take a much more optimistic view of the future. I want to see much more efficient electoral administration. So we need to see more robust, more independent electoral management bodies. But at the same time, I also want to see greater appreciation for the sacrifices that electoral officials make. Often electoral administration is a thankless job, but it can be quite dangerous as well. It's fraught with its own risks and its own challenges. And elections, quite frankly, are very, very high, there's a lot of tension on election day, and there's a lot of possibility that things might go wrong. So we need to see much more appreciation, not in an uncritical way, but just in terms of a much more sensitive understanding of what the challenges that sort of function entails. I want to see much more credible electoral processes as well, and that as a corollary to that, that would lead to less pressure on the courts to intervene and try to correct some of these structural problems with electoral systems. So yes, I would like to see vulnerable and marginalized groups play a much more prominent role in electoral processes. So young people, I want to see young people assert themselves even much more vigorously and peacefully as well in electoral processes. We need to pay more attention to the plight of persons living with disability, for instance. We need to talk about the structural factors that exclude certain people from playing active and meaningful roles within political processes. And hopefully all of this will inure to the consolidation of democracy in the long term.
You mentioned the disability voting. This is where I would point to the chapter written by Enira Bronickaja and to not so optimistic rulings by the European Court of Human Rights on disability and accessibility of buildings, not just in elections, but also in accessing buildings in general. There's been a series of rulings in the last few years in which persons with disabilities did not succeed. And there's also been 3 rulings on Denmark, Spain, against rulings in favor of the governments of Denmark and Spain, and against persons with intellectual disabilities who fought for their franchise, for their right to vote, and they did not succeed at the European Court of Human Rights. Luckily, we have the CRPD, the UN Convention, and the committee that rules very differently from the European Court of Human Rights. So those who live in the countries that are parties to both conventions, they can have some optimism, because these countries have to obey the CRPD, even if the European Convention does not protect them. They're protected by at least the CRPD. Is there anything at the end that you would like to say about the election law, the future of elections, how you would like to see them in a few decades from now?
Just to say, I think electoral processes can be quite fragile, and it's critical to have meaningful elections that help people really help elections be more than just a popularity contest, but something where people are meaningfully choosing between different possible leaders and finding solutions to the problems a country faces. And to do that requires involvement by a whole range of stakeholders. And we were saying it's important that election administrations play their part. Observers in the courts are a critical check and balance on the work of election administration and what parties and candidates are doing. So they need to be there in the case of observers, so people can hear about what problems have arisen, and for courts to be able to rule where needed, where there has been a problem. But our work as observers and the work of courts also needs to be subject to scrutiny. Thank you.
Yeah, and just to echo that as well, these are very grim times for democracy across the world, so it's important that more attention is paid to election law. It's important that all democratic stakeholders also come together, and we need to have all hands on deck, essentially, working to reverse the trends of democratic decline we're seeing in several regions of the world. And we need to just essentially conceptualize democracy building as a collaborative effort. So that's what I would like to see going forward.
Thank you, Hannah. Thank you, Ugo.
Thank you.
And at the end, I would like to thank Keble College for hosting the event. I would like to thank Alma Mater, Europaea University, and the University of Maribor, and the Fordham University that supported me during the research. David Schultz, who conceptualized the book and edited it, and of course Routledge Routledge and several people with Routledge who were with us through the whole process, and Daniel Sitter, he's only mentioned in one place in the book, but he assisted me with in the last few years a lot, and my wife Živa, I could do the book because you did everything else. Thank you, everybody who is watching this, and hopefully we will do a similar event in the future.
Thank you.
Thank you as well.
Thank you, Jurij.